What is arbitration and mediation? Arbitration and mediations are different types of alternative dispute resolution, also called ADR. These are alternatives to going into a courtroom and having a judge or a jury decide your legal issue. Mediation allows parties involved in civil disagreements such as divorce, landlord-tenant law, probate disputes, breach of contract, small business disputes, all those types of things can bring in a mediator to help the two parties come to an amicable agreement. In arbitration, they voluntarily hand over their case to an arbitrator, who is a type of judge, who will examine the evidence and arguments from both parties and then makes a binding decision. The difference between mediation and arbitration is the fact that mediators generally do not render a legally binding decision, while arbitrators can if the parties agreed on it beforehand. In mediation, the burden to decide the case falls on the parties themselves, with the mediator only acting as a guide to help the parties come to reach their own voluntary settlement agreement. Arbitration, on the other hand, is more like a regular trial, with both opposing sides being able to call witnesses, deliver arguments, and present evidence. And then the arbitrator, who is chosen by the parties beforehand, would then deliver a binding decision. If you have further questions, feel free to submit a contact form to AskTheLawyers.com.